Can you describe what happens in a personal injury lawsuit?
To start any lawsuit, including a personal injury lawsuit, a written complaint is filed describing the facts of what happened and the legal theory that entitles my client to a legal judgment and compensation for damages and injuries in a personal injury case. There are different rules then regarding written paperwork that's filed by the plaintiff, my client, and on behalf of the defendant. Ultimately, that's resolved so that the issues are clearly known in writing for the court, and there is a process of what is called discovery. Written questions are filed by each party. In a personal injury case, those questions are fairly standard regarding to do with how the accident happened, the injuries, the medical bills, any witnesses, expert witnesses, questions like that. Requests for document inspections are part of discovery. Those basically involve, in a personal injury case, accident reports and medical records. Most of the time, if the case goes far enough, a deposition of the plaintiff certainly is done by the defense lawyer, and I will spend time as necessary to help client prepare for that. A deposition is oral questioning, usually at my law office. The client is put under oath, the court reporter is there, and the insurance lawyer questions the client under oath about the case. Very often in personal injury cases, the defense will ask that, quote, an independent medical exam, close quote, be conducted. I put that in quotes because it's not necessarily independent, that the insurance company or defendant hires a doctor of their choosing to examine the plaintiff and get their own opinion about the cause and extent of the injuries. There are mechanisms for trying to settle personal injury cases, either special mediation that the court might refer the parties to, either within the system or private mediation, a judicial pretrial at which an experienced judge who's heard hundreds, if not thousands, of personal injury cases listens to the lawyers and suggests to the lawyers to suggest to their clients what that judge, based on his or her experience, thinks is an appropriate amount to settle the case based on the facts and the injuries. Scheduling orders are issued. Usually we are notified in a personal injury case 3 to 5 months in advance of a trial date. And at that point, in addition to all the preparation that's already been done, as soon as the trial date is set, there's some immediate preparation that the lawyer and the client need to work on. At trial, and I've tried many cases, both to court and jury, we pick a jury. The process in its outline is this. We pick a jury in Connecticut. That's done in state court by individual questioning of each prospective juror. We have challenges, a limited number of jurors that we can excuse without really having to state a reason. Once the jury is selected and the trial starts, each lawyer gets up and, at the discretion of the trial judge, makes a brief opening statement. Evidence is put on. The plaintiff would always have to testify, except in a wrongful death case, obviously. Expert witnesses, both as to liability and then medical doctors regarding cause of injuries and extent of injuries, are often involved in personal injury cases. And at the end of the evidence, the lawyers for each side make a closing statement to the jury, and the jury makes a decision. In conclusion, in a personal injury case, the lawyer in my office, me and my legal staff, work closely with clients to help them get through the process, deal with the insurance companies and the medical bills, and obtain the best result and the best compensation for the client.